Margaret Hinkle. We welcome the members of the public who are attending today. Let me begin, please, by engaging in a roll call. Commissioner Baker?
Morning, present.
Commissioner Bluestone?
Good morning, present.
Commissioner Calderon?
Good morning, everyone. Here as well.
Commissioner Crispin?
Morning, I am here.
Commissioner Hall?
Good morning, present.
Commissioner Kazarosian?
Good morning, present.
Commissioner Talley?
Morning, present.
We do have a quorum. Commissioner Luma is unavailable for at least the beginning of our meeting. Let me now ask, please, for a motion for approval of the minutes of our last meeting that held on December 18th of 2025. Is there such a motion?
Motion to approve.
Is there a second?
Second.
Thank you. Commissioner Baker?
Yes.
Commissioner Bluestone?
Yes.
Commissioner Calderon?
Yes.
Commissioner Crispin?
Yes.
Commissioner Hall?
Yes.
Commissioner Kazarosian?
Yes.
Commissioner Talley?
Yes.
And I also approve. That's unanimously carried. Next, the Executive Director report. Enrique, please.
Thank you, Madam Chair, and good morning, Commissioners. I will start my report today, like I have done a couple of times in the past, by acknowledging the very sad news of the recent passing of an active police officer in the Commonwealth, Officer Stephen Laporta of the Uxbridge Police Department died last week because of the injuries he suffered during a crash that took place while the officer was helping another motorist. Our sincere condolences to his family, the Uxbridge Police Department, and their community. I will share my screen in a moment, Commissioners, and take you through the presentation like I normally do. So, can everybody see this? As a reminder to those in attendance, the Commission does not take public comment at its public meetings, but instead we ask members of the public to reach us by using any of the resources in the screen. We accept and very much appreciate written comment at any time. And speaking of written comments, I will mention that just this Tuesday, we did receive a letter from the Mass Chiefs Association regarding the Commission's recent guidance to constables. In their guidance, in their letter, they state that given our guidance from the last Commission meeting, they felt the need to remind and clarify for their membership certain principles and practices regarding police activities during the eviction or foreclosure process. In essence, they reference a Massachusetts law that prohibits the involvement of police in civil proceedings. This letter came after we distributed the packet, but we will include it in the public packet that we post to our website after this meeting. We have taken their comments on their advisement, and if our legal staff feels that we need to amend or append our guidance, we will come back at a future meeting and to have those discussions. So again, as part of my report today, I will provide a brief general update of the operations and some of the projects we are working on at this beginning of 2026. I will also summarize the financial results for the second quarter of the fiscal year. We continue to make efforts to ensure that the data we are required to report on is consistent and uniform. We have taken steps to generate reports and data metrics that are regularly reported on to come exclusively from our systems of record. These efforts are ongoing. We have information that is required to be submitted by March 15 to the legislature for the prior fiscal year. And we also compile, as you well know, an annual report of the activities of the previous calendar year. We are compiling that information as we speak. At some point in the spring, we will be presenting testimony before the Joint Committee on Ways and Means And for that testimony, we typically also put together key metrics of the results and activities of the previous year. We do this, among other materials we compile, to substantiate our budget request for the following fiscal year. As mentioned, our approach is to ensure we have identified the relevant data sources and all the reports to facilitate these activities, and that those are consistent with the reporting requirements and from year to year. Finally, as we have mentioned in the past, we are looking forward to deploying the initial phases of something called a business intelligence tool during this beginning of this calendar year to aid in the overall effort of reporting and data management.
Enrique, can I just, I'm having trouble hearing you. I'm sorry.
Okay. I apologize. Let me.
That's good there, right there.
Okay. I see that I stopped sharing. Is that correct? Let me see if I can.
You sound great now.
Okay. Thank you. Sorry about that. Can you see my screen now? Okay. All right, I mentioned the business intelligence tool. We'll continue. We'll come back to that topic at a future meeting. We are looking forward to deploying it as we speak. Let me advance my. I do want to mention today the recent project that we did relative to an integration with the Criminal Justice Information System, also known as CJIS. We contracted with a CJIS authorized vendor, and this project required multiple coordination efforts and the implementation of security protocols around it. As part of this integration, Post receives a notification if an officer in our database has an interaction with the court system. The most common notifications or use cases is in which an officer might need to be suspended by Post because they are charged or indicted for a felony. We completed the integration last November and have been receiving notifications for approximately 2 months. During this time, we have been working out internal procedures and ensuring integrity of such process. I'm happy to report that the integration is working as intended. I will note that agencies are still required to report to Post these incidents within 2 business days. But there have been some use cases in which perhaps the officer was no longer working for the agency, was still certified, and it's still the officer still we were still required to suspend their certification. We in one other use case, the agency did not remember that this type of incident was required to be submitted to Post. So we called them up and reminded them to enter that information into our portal. So we're very happy the way that this system integration is working, and it furthers our efficiencies in terms of the work that we do. In terms of moving on to outreach and engagement, last December, at the end of last year, I attended the Mass Chiefs Association annual meeting. In that meeting, they welcomed Southbridge Chief Shane Woodson as their new president. Chief Woodson replaces Chief Chris Belmonte from Bridgewater, as the president of the association. I will mention that Chief Belmonte has been rather engaged with posts, as is also the case with all other past presidents and their executive board. We look forward to continued dialogue and collaboration with the association like we have done in the past. I will move on to provide you with a brief update of our finance and administration activities. We have ended the second quarter of fiscal year 26. The end of December marked that end. We have committed 49% of our budget, which is completely aligned with where we are, which is given that we are halfway through our fiscal year. This is also an indication that this year we will likely have a lot less reversions compared to prior years. As is common practice, our finance team has included in the packet the treasurer's report and a memorandum that describes those activities in more detail. The memo in the packet highlights again those details, but I will highlight that the personnel planning has paid off. We have a slight surplus, just over 2% in payroll, thanks to the fact that we've been managing the filling of certain positions. You'll recall that we did this for a couple of reasons. To make sure that the current payroll, that we were going to be able to meet the current payroll because we were funded at a lower level than we initially anticipated just a year ago. And we are also awaiting what will hopefully be a better picture for fiscal year 27 to ensure that we can sustain all our hires and those that we had planned to hire for fiscal year 27. I will also mention that during the first quarter of this fiscal year, we announced that our information technology expenses were a little bit over budget because of some anticipated increases to the service rates, the service contracts that we have. I should mention unanticipated increases to the service rates, but this is completely manageable, and we expect to be in a sound financial position at the end of this fiscal year. I will also mention that we are already taking a lot of activity relative to fiscal year 27 planning and coordinating with the administration. We understand that the governor will be filing their budget in 2 weeks. We are awaiting a recommended appropriation or any news about it and how that funding level will come back. We unfortunately have no indication or idea as to what is their current thinking. We are in the midst of the maintenance exercise for the legislature, where we will present our original fiscal year 27 request of $9.590 million. We had requested an 8.6% growth, or approximately $750,000 over our current budget, to enable us to continue to grow with as planned. And again, as I mentioned earlier, just in the spring, we expect that we will be providing testimony in front of the Joint Committee of Ways and Means shortly after that budget is released, so that we can substantiate, as I mentioned, our budget request to the legislature. I will close with mentioning that we are welcoming Kim Shotford, who was a legal fellow with us in the past year, and she has now accepted the position of Information Management Counsel and Record Access Officer in a full-time basis. So welcome, Kim. It's great to have you. We have also posted another position for the same kind of attorney. We're quite busy when it comes to this topic, and we're also backfilling that position given recent departure. We just posted 2 additional intake coordinators. That's another area of quite a bit of activity relative to review of complaints and incident reports that continue to grow. And we have begun the annual process really of thinking about projects that we will have for interns that come around the summer, but sometimes throughout the year. And those are great additions to our activities. We have a total count of 51 at this moment and expect again to grow to 53 in the short term, and we'll continue to grow funding provided depending on the next few months when we hear more from the legislature. Let me pause there, commissioners, and see if commissioners have a question or a comment. Hearing none, that concludes my report, Madam Chair.
Thank you very much, and thank those who have worked with you, Enrique. And I think at this point, we move on, please, to our financial advisor, Eric Rebello-Pradas.
I took that part, Madam Chair. So unless there's questions for him, we're all set.
Any questions for Eric? Thank you very much. And Eric, thank you and those who have worked with you on our financial situation, and also our commissioner, who is our treasurer, Commissioner Luma. Then moving on, please, I believe, to the recommendation, item number 4 on the agenda, the recommendation to form an advisory committee.
Thank you. I will take that, Madam Chair, and we can take, of course, any questions or comments throughout. I have included in the packet a memo that outlines some recent discussions, really, and correspondence from outside stakeholder groups relative to the formation of a subcommittee and advisory committee. Given just the discussion from the last couple of times, we believe it has not been concluded, so we were hoping that commissioners will ultimately take a vote on this question, and then we can go from there. We are asking that the commission vote on whether to form an advisory committee as a matter of threshold first, because there's been some discussion as to the composition of one. But we would like to take the first question first, and then come back with recommendations if it was a successful vote, or end if it wasn't. I just wanted to recap a little bit from the memo. We've had the memo outlines the materials that we have received. It started with a letter from the chiefs in October of last year. We met with them after having had that discussion with the commissioner at the October meeting. They further clarified their recommendation in a November letter, in which they do recommend that the advisory committee be comprised of both law enforcement and other subject matter experts, not necessarily law enforcement, which again has been a topic that the commission has debated on. We've received a letter from MACLEA, the Mass Association of College and Universities Law Enforcement Campus Law Enforcement, with a lot of members there in support of this idea. They would love to participate. Members from MAPLE, the Mass Association of Police, Professional Law Enforcement, who are mostly retired police officers, also recommend that we implement, or that the commission form an advisory committee. And the union, MASCOP, is also in support of the idea of a subcommittee. They actually oppose the notion that it be only chiefs, but that's not what the chiefs recommend. The chiefs recommend that it be also a a diverse law enforcement committee, but also one that includes other subject matter experts that, again, need not be law enforcement. I do want to address a comment that came up last time when Commissioner Talley asked if this was a need to have or a nice to have committee. I was a little imprecise, and I want to be more precise in my response now. It is not mandatory. It is not in the statute. In my experience, some of these advisory committees are often or sometimes put in legislation, and that makes it a mandatory thing. We don't have that in this case. But I would put this topic in the category of need to have for the following reasons. We are entering a phase of coming up with standards for agency certification that, in my view, really means that we're going to be asking agencies to do a lot of different things, many of which many agencies are already doing, but as a way to address system-wide improvements, we believe that it's good to have throughout. And so the composition or a good thing about an advisory committee is, just as I have mentioned in the past, where people feel that they have had a say into things, into the early crafting of policy questions, and that they have been listened to. That generates a lot of buying, and it positions Post and the mission of Post to have a little bit more effectiveness, if you will, if with something like a subcommittee, like I have mentioned. Now, it is true that it takes perhaps more resources. It depends on who's in the advisory committee. We could have we could have a lot of healthy discussion around the composition, and we could also and the commission would retain the ability to change the composition of the advisory committee at any time if we get for whatever reason an indication that there's members that are participating but not trying to be productive. But in my experience, when these kinds of committees are subject to the open meeting law, which is what would happen here, there's less incentive to be a contrarian at all times, and there's a greater incentive to be constructive and productive. So, with all of that, I wanted to put this matter for a vote if the chair would agree. Again, I think it's worth trying ultimately, rather than that not having tried it, altogether. Looks like Commissioner Casarosian has a question.
Yes, thank you. I've thought a lot about this, and I completely understand your perspective on it, and I do agree that Post can always benefit from advice and counsel from different groups, whether it's in an advisory committee or subcommittee form. But first, I'm going to say it's my understanding that this committee or subcommittee that would be created under Post, it wouldn't have any higher priority as far as how we consider any of their recommendations or advice. So that in and of itself doesn't, I don't see the need to have it be a committee under Post. And here's my concerns. And you sort of touched on it when you talked about the open meeting law. We have ultimate responsibility for any of the committees that are formed under Post. We've already had, the open meeting law is no easy law to navigate, and there are many traps for the unwary, and we're the ones that are responsible ultimately. We've already had at least one lawsuit relating to it. I don't think anyone wants any more. I see nothing that stops any of these associations from putting together their own advisory committee that would regularly report to us, and we would give them the same kind of consideration and respect that we would for anyone that participates. I was originally also concerned that it was strictly limited to law enforcement, but I understand that's not so much the position here. But again, all of these associations, whether they're law enforcement based or whether it's ACLU or Lawyers for Civil Rights, we welcome and we encourage input and we give them great consideration. But we also, I want to point out, have on our commission, 1/3 of our commission is comprised of law enforcement representatives who were specifically set out in their particular fields in law enforcement to cover the different ranges of input that we would then get from these proposed associations who want to put together a committee for advice. And our commissioners do a really superb job of, in my opinion, providing all of those perspectives and guiding us when we have questions or advice or input from some of these outside associations. So I don't see the value added just for me. I mean, I'm willing to be convinced, if I can, of having this kind of a particularly proposed committee or subcommittee that runs under post, because we've got an awful lot to do as it is, and trying to oversee a committee like this, I think, will be unwieldy, it's dangerous, and it creates a lot of liability that concern me pretty deeply.
May I react to one aspect of your comments, Commissioner?
Of course.
The one thing I would mention is that you might recall that the lawsuit that was levied on us by MassCop was in response to the fact that I did form a couple of working groups early on to consult like we did, because we had to craft early policy, and they alleged that those should have been subject to the open meeting law. Now we disagree with that, but you know what they were alleging again is that those meetings should have been part of a public meeting, which is something that we would definitely do if the commission agreed to form a subcommittee. It is also additional resources in terms of staff, but I don't believe that there would be additional work of the commission. It would be more structured in terms of the materials that would come to the commission relative to those policy ideas. But I take all your comments, of course, respectfully.
Thank you, Enrique and Commissioner Kazarosian. Commissioner Bluestone?
Yes, thank you. I just wanted to say that I do recognize why this is an important topic and one that we have discussed in the past. And I think, as Commissioner Calderon pointed out, this is a topic that we have taken a vote on before, because it really sounds to me like now we're kind of moving more in the direction of an advisory board that is more representative, that is more diverse. And in my view, that is our commission. We were set up to be a civilian commission. We were set up to be representative of the diversity of the Commonwealth. And we have, as Commissioner Kazarosian points out, law enforcement officers already on the commission. The reason I was initially in favor of an advisory board that included law enforcement officers was because I do think it's helpful to have more input around how the policies that we're considering are actually going to impact departments in real time in terms of what it means to make changes within their system and how overburdened they might be. But I am not in favor of a advisory board that essentially replicates what I believe we're already doing.
Thank you. Commissioner Calderon?
Thank you, Madam Chair. I don't want to beleaguer the conversation or the vote too much, but just to weigh in, I completely agree with both the commissioners that already spoke. I know I've weighed in heavily along the way, but clearly the legislature did not intend for our commission or anything that we do to be heavily weighted towards law enforcement. And I am the voice of the law enforcement community through the policy group, which represents the rank and file and many chiefs. So I'm against this clearly because it would give the impression of a lack of transparency. Since our inception, we have given the opportunity for anyone, any organization, police or not, to weigh in on the decisions of formulations of rules, regulations that we bring forward. I just think this is a bad look. I think that it gives the impression that we're favoring law enforcement more so than other entities. And I just see too many changes as we continue to talk about this, changes in meaning that recommendations from outside groups that are predominantly chiefs groups. And it went from, I think, a 9-person recommendation to now approximately 19. And just reading the structure of the 19, although it says it'd be made up of different representatives, those representatives that have specialty in law enforcement, ones that would testify or create regulations, they're former law enforcement specialty members. So it would still be 2/3 chiefs. And that is not what the legislature intended this commission to do or be involved in. So I'm against the committee with my fellow commissioners, and I would like to take a vote so that we can put this to rest once and for all.
Thank you. Commissioner Talley, please.
Well, just one last thing, not to belabor the point, but we got to think about the end in mind. What is Post not doing that would necessitate a need for this group?
Well, we don't have a regularly scheduled check-in with any particular outside group. I think, we are less proactive, I guess, than what an advisory committee would cause us to be relative to previewing, consulting, and hearing feedback from groups. It's been, let's just say, informal. It's been, subject to the letters we receive, we distribute them to the appropriate parties, and we have that dialogue at the staff level. A subcommittee, like I'm recommending, would cause us to be structured, scheduled, and would cause all these outside, members to have, an expectation of some regularity to review policy matters that are coming along. A case in point, if I may, just one. I know the Chiefs Association watches our meetings. They can consult at any time, look at the tape, after we post it. They sent us a letter, just as I mentioned earlier, this Tuesday, relative to the guidance that we issued at the beginning of this year, which was the result of the discussion we had in December. But they seem to have missed, frankly, the fact that we had an earlier discussion back in October of that topic, of the topic of constables. We presented initially for you commissioners 2 documents, not for a vote, but for consideration. When we do that, we assume that people like that are interested stakeholders would view those documents, would understand them, and then provide comments. And at least this one, those comments came after they we had issued the guidance by vote of the commission in December, and we and I and them highlighted that they would have been probably better timed had they come after October when we had the initial discussion, but before December when we had the final vote. So they actually in their letter they highlight that had we had an advisory committee, that would not have been a timing issue. It wasn't, but I sort of agree. But I would have liked to have their letter earlier than the December when we consider this in the December meeting. So that's just one example. It's really around scheduling and expectation of cadence to review matters of policy.
Thank you, Enrique. Commissioner Crispin, I think you had your hand in the air before. Did you want to add anything to this before we take the vote?
Just real briefly, I think I understand the concerns that Commissioner Calderon brought up, but I think despite the diversity of this commission, I don't think we have a monopoly on all the possible issues. And I don't know whether or not we need a whole subcommittee to bring in other perspectives, but I think it's useful. I think the only issue tends to be that the individuals who bring up these issues tend to be from the police perspective. So if we're going to open this up, I think it's important that we educate the public so that they can also express some of their concerns. But I would say it's useful to hear from outside members of the commission and from diverse perspectives. I think this is a very diverse group, but again, I don't think we have a monopoly in all the possible issues.
I think thank you, Commissioner Crispin. Commissioner Kesrosian again, please. And then
Thank
I do want to get a vote because we have a number of other matters to take up and we are losing some commissioners a little bit later. So Commissioner Kesrosian, please.
Sure. Thank you. Very briefly, I completely agree with Commissioner Crispin, and also, but I do want to say that nothing stopping anyone from providing us with this diverse perspective, and for us to then be the watchdogs of how these diverse perspectives meet and come back to us. I'm concerned about that. Nothing stops them from setting up their own committee to advise us. I don't want to be the one, I don't think we should be the ones in charge of that, but we're as open as we're always going to be, whether it's a subcommittee by post or not. They're not going to get any higher consideration just because it's a subcommittee of post. We're going to listen to them whether they are or aren't. So that's my bottom line on that. Thank you.
Thank you. Commissioner Calderon.
No, I was just going to comment on the executive director's piece on the constable letter. I'm of the opinion, Mr. Director and my fellow commissioners, any organization that's concerned in what this body and this commission is trying to do successfully moving into the future should be part of our meetings every time we have a public meeting. And we shouldn't feel responsible to check in with outside entities that may be concerned when they feel like being concerned. So this is an extremely important commission we run. Again, I'm a rank and file guy speaking for 20,000 rank and file guys. They put me here, and it should be open and transparent, and we shouldn't be chasing organizations, police or otherwise. Thank you.
Thank you. Any other commissioner wish to say anything before I call for a vote? Yes,
Can I say one more thing, Madam Chair?
of course.
What we were asking is to take a vote on whether to have a committee or not altogether. There's been some discussion as to the composition. And my recommendation is that we table that for after the vote. If the vote is in the negative, then we don't have to worry about the composition anymore. But if it's in the positive, then we can have a discussion now or later as to who should be there. So I just kind of wanted to mention that as a recommendation.
Thank you. All right. So then we are now going to take a vote on simply the question of forming an advisory committee, of having an advisory committee, not the composition of the committee or the size of the commission. Commissioner Baker, yes or no on that?
Yes.
Commissioner Bluestone?
No.
Commissioner Calderon?
No.
Commissioner Crispin,
No.
Commissioner Hall,
Yes.
Commissioner Kesrosian,
No.
Commissioner Talley,
No.
and I'm also a no. So I think that at least for the present, there will be no advisory committee formed. Moving on from our agenda, the next matter, I believe, is the legal update, and I turn to our general counsel, Randall Ravitz.
Thank you. I will try to share my screen. Okay, you should see a PowerPoint presentation now. Is that right? Okay. In the packet for the meeting is a proposed document entitled Guidance Regarding Heads and Officers of Law Enforcement Agencies. And just by way of background for members of the public who may be watching, Chapter 6E, the statute that governs the commission and in many ways governs law enforcement officers and agencies, as well as commission regulations, speak in terms of law enforcement agencies and law enforcement officers. They use those terms throughout, and that's who the provisions extend to. Now, the definition in the statute of law enforcement officer and officer extends in part to any officer of an agency, meaning a law enforcement agency, including the head of the agency. And the statute also charges the head of an agency with performing certain specific functions, and commission regulations follow suit. But in some cases, whether an individual is the head of the agency or is an officer of an agency might not be obvious and could be the subject of debate, especially if the individual thinks of themselves as a civilian. And so this guidance, generally speaking, is intended to help identify who should be considered heads of law enforcement agencies and officers of law enforcement agencies, strictly for purposes of applying Chapter 6E and the commission regulations, not for any other purpose. And it's based on how the statute is best understood. So it doesn't intend to create any new rules, but only to set forth an interpretation of the statute that seems most sensible. And that's largely based on the text and structure of the statute, accepted principles of statutory interpretation that have been repeated by courts for many years, numerous sources defining terms such as officer, law enforcement officer, and police chief, and discussing the powers of police chiefs and officers, from other statutes to regulations to judicial opinions to dictionaries, and also the benefit of commission experience, things that we've seen over time, such as how and where confusion might arise. The proposed guidance does not apply to sheriff's office personnel because they're given some distinct treatment in the statute and specifically in the definition of law enforcement officer. Now, Section 1 of the proposed guidance would deal with the head of an agency, and it would say that the commission will ordinarily view the highest level person who exercises day-to-day supervision and control of the law enforcement functions of a law enforcement agency as being the agency head, again, just for purposes of applying Chapter 6E and commission regulations. And it would say that the commission respects that different entities have different organizational structures and different position titles. But Chapter 6E contemplates that each agency will have this single individual agency head who will be accountable. And that's probably clearest from the sections of the statute that require an agency to make certain reports to the commission, specifically regarding disciplinary matters, through an agency head. And they provide for that person's own certification as a law enforcement officer to be administratively suspended if that is not done. So again, it speaks in terms of a single individual agency head. And so in order to give effect to those provisions, the commission may need to call on an agency to identify such an individual if that hasn't been made clear already. And if that is still not done, the commission may itself need to identify the most suitable person to be treated as the agency head, again, just for purposes of Chapter 6E and the commission's regulations. Section 2 of this guidance would deal with who is an officer of an agency. And it would state that certain individuals will necessarily be considered an officer of an agency. A police officer, someone who is empowered to make arrests or perform substantial law enforcement functions by virtue of being affiliated with an agency. And someone who is affiliated with an agency and tends to exercise the law enforcement powers of that agency or holds themselves out as a law enforcement officer with the agency. But then additionally, an agency head will be presumed to be an officer of an agency, not only because that definition refers to an agency head, but also because, again, Chapter 6E contemplates that an agency head will be a certified officer, someone whose certification can be administratively suspended if certain duties in the statute delegated to agency heads are not performed. And so treating an agency head as an officer prevents those provisions, that enforcement mechanism, from being circumvented. And it also ensures that agency heads meet certain standards themselves and that they're subject to regulations and that they're accountable, which in turn can help ensure that their agencies function well. Now, also, the commission, according to the way this guidance is structured, could determine that another individual is an officer of an agency upon considering all relevant aspects of that person's position. And it lists certain factors that would tend to point in that direction, but making clear that none of those is dispositive and that the list is not exhaustive. And for these purposes, when we speak in terms of law enforcement functions, the guidance offers a list of certain forms of conduct that can be seen as law enforcement functions. And again, that's based on, as with other areas, on a series of existing sources that elaborate on things like law enforcement functions and what it means to be a police officer. The next section of the guidance would say that the commission may need to seek information from agencies or officers or perhaps others in order to determine whether an individual is a head or an officer of an agency. And there are provisions of the statute that allow the commission to obtain information when it needs to. And then the next section would say that we understand that this explanation of how the commission understands the statute may cause some people to revisit their own assumptions about their status, and they might need to take certain steps that they weren't planning to take to bring themselves into compliance with the statute and regulations. But the commission regulations allow for accommodation of individual circumstances in various ways. There are a lot of things built into the statute, into the regulations, that provide, for example, for extensions of time and conditional certifications and so forth. And while we can't speak for the MPTC, we can look at their regulations and see that they too accommodate individual circumstances when appropriate. Now, the next section would simply call attention to the implications of all of this, advising people to familiarize themselves with how Chapter 6E and commission regulations and related sources of law impact them, depending upon how they are classified. And so agency heads and officers are subject to various requirements and restrictions, and this guidance would generally summarize those, again, advising people to look at the statute and regulations themselves. But it would also note that even if people are not agency heads or officers, there are certain provisions of Chapter 6E that might govern them. So Chapter 6E prohibits all public employees in Massachusetts from retaliating against employees for providing information or testimony to the commission, generally speaking. And anyone inside or outside of law enforcement may be required to provide information to the commission upon a lawful demand. So it just concludes by calling attention to those provisions that govern law enforcement agency heads, law enforcement officers, and others. Now, as the executive director said a moment ago, and other people said in a different context, the commission is always interested in hearing feedback from inside the agency and outside the agency, and certainly this matter is no exception. So we welcome any feedback, and if the chair would like, I can entertain any questions that anyone may have.
Thank you, Randy. Do any commissioners currently have any questions on what he has just explained in the proposed guidance? Don't think I see any hands in the air, so with that, we'll move on to the next item on the agenda, which is agency certification standards. And back to you, Randy, please.
Thank you very much. And as usual, I will turn the floor over to Annie Lee.
Good morning, Madam Chairs and Commissioners. Let me just start sharing my screen. Alrighty. So today I will be presenting two agency certification standards for your consideration. The first standard relates to juvenile operations. I will be presenting two additional revisions to this standard, and pending any final questions or feedback, I anticipate asking for your preliminary approval. The second standard of the day will be internal affairs and officer complaint investigation procedures. This is the first time that this standard is coming before you, so I will be looking for your initial reactions and feedback and will not be seeking your preliminary approval. So turning to our first standard, juvenile operations, a copy of which is available starting at page 71 of your packet. This standard was last before the Commission in November when a set of revisions was presented for the Commission's consideration. Those revisions reflected feedback provided by a diverse group of organizations, including the MPTC, the Massachusetts Chiefs of Police Association, Strategies for Youth, and the Juvenile Court. The Commission was satisfied with those revisions as presented in November, but suggested additional revisions, which I have drafted and will present for your discussion momentarily. Those revisions concern the two elements that are highlighted in yellow on your screen, the first of which is assistance or support to the Department of Children and Families, and the second of which is child requiring assistance matters. On DCF matters, the Commission suggested during its November meeting that a proposed sub-policy or provision concerning an agency's provision of assistance or support to DCF would benefit from more detail, as DCF matters can be fraught and difficult for everyone involved. And so what we've done here is try to elaborate on the original provision, which just said sort of figure out officers' responsibilities, their roles, their limitations, things like that. We elaborated on that by first specifying that officers are meant to work with DCF personnel in an assistive or supportive role. Second, that their responsibilities in DCF matters are to maintain safety and manage any related risks. And third, to utilize de-escalation tactics and techniques in accordance with use of their agency's use of force policy, as well as the Commission's use of force regulations and applicable training. On the second element, which is child requiring assistance matters, similar to the feedback that we received on DCF, the Commission suggested that a sub-policy or provision concerning responding to a youth who is a subject of a CRA case would benefit from more detail. And here we've provided that detail by first specifying when an officer may take a youth into protective custody under the CRA statute. Second, specifying the applicable obligations and prohibitions when an officer takes a youth into protective custody under the CRA statute. And then third, directing officers to provide medical care to a CRA youth if appropriate. And so that concludes the revisions to the Juvenile Operations Standard. As I said, if there are any questions or reactions, happy to take that.
I think Commissioner Calderon has a question.
Thank you, Madam Chair. A question on the shackling or similar restraining of the youth that we want to implement, prohibiting that from being done. Was there a discussion, maybe that I know we're having the first of a few different conversations here, but has there been a discussion within the Commission or a concern about the juvenile that may be dangerous to themselves, may be dangerous to the people transporting them. It seems somewhat unreasonable to say it's prohibited absolutely all the time. From a law enforcement perspective, there are juvenile individuals that do become violent or can become a harm not only to the transporters of the general public, but to themselves. And sometimes it is appropriate, even if we're cuffing them, restraining them in the front of their body. Was there a conversation about that? And if not, we should have it because that is a grave concern.
So Commissioner Calderoni, I hear that comment. We did not have a discussion on this specific provision because as originally presented in November, this provision was significantly more general, saying again, officers or agencies should detail, officers' roles, their responsibilities, limitations, any obligations. I will, however, note that the prohibition against shackling and using similar restraints comes from the CRA statute.
Meaning what? Because currently we do restrain juveniles. So from a post standpoint, are we trying to prohibit that? Or am I misunderstanding what's in front of me?
I think from the post standpoint, we're really just incorporating the obligations and prohibitions that come in through the CRA statute. And I believe that applies specifically when the child is in custodial protection. So if they're engaging in, potentially criminal behavior, then I think that might take them outside of the custodial protection setting. But however, if it's simply all that exists is a warrant for protective custody that the juvenile court has issued and officers responding to that, and there's no other basis for such action, I believe the CRA statute would apply there. And I believe that at least one other commissioner has experience in this field, and so I'd be happy to sort of defer to their expertise.
Well, I'd like to recommend that we strike that line, number 5, until we can clarify what exactly that means. You keep quoting the CRE, but I can tell you by practice in law enforcement today that when we take juveniles into custody that could harm themselves, there's no criminal behavior there, but we do restrain them because it's for the safety of the juvenile. So for us to implement or put on paper from a commission standpoint that we prohibit it, that is not true. So I'd like to recommend that we take that out and further investigate that.
Thank you, Commissioner Calderon. Let me see if Commissioner Bluestone has a comment with regard to this issue.
Yeah, I think that it's clear that what we're trying to say is that, that police are entering into these situations in a supportive role, and that we're recognizing that these are juveniles who are not in the criminal justice system per se. But I agree with what Commissioner Calderoni is saying. I keep saying your name wrong, I'm sorry. I agree in the sense that these are sometimes very volatile situations, and I don't think we can ask law enforcement to go into these situations without having, a full range of options available to them if the situation becomes dangerous or out of control. So I share that concern as well.
Thank you.
Annie, are you willing to strike that particular provision with an eye towards getting a vote with it being stricken?
Yes, though I'm happy to come back with more sort of detail about this. I'm happy to sort of reach out to the folks who have more expertise in this, if that would be helpful for the commissioners. But if this is the sort of only item that would prevent a vote from it happening today, we can certainly strike it out. Of course, that nothing is sort of final, and this has not gone on to final promulgation or anything. So I can always provide more information to the commissioners when this does come up for a final vote.
I'm sorry, you're not asking for a final vote then?
For the preliminary approval, which is different from the vote. When I say final, though, I mean the vote to engage in the publication of the regulation and the Secretary's Register. That would sort of start off the promulgation process of a regulation.
Let me hear first from Commissioner Crispin and then from you, Enrique. I remain a little bit confused. Commissioner Crispin?
Yeah, so I think the CRA is already written. I don't know that we can go back and change what the CRA says. I think part of the way the CRA is written is a lack of insight from those who do the job, even in those situations where there's a CRA and there may be a need to transport that young person to a hospital. And if they're being volatile, hostile, physically combative, even in an ambulance, there may be a need to restrain that individual. So I don't know that that's something we can change. I think maybe the way it's being done practically is different than the way the CRA intended it to. So this may again be something that we may need to flag for the legislature in terms of how it practically applies to those who do the job.
Thank you. Enrique, please.
Thank you, Madam Chair. My recommendation is that we simply strike out that reference as Commissioner Calderoni and Bluestone are recommending. And, take a vote if the commission is ready, and then, look to adding future clarification if that's necessary.
All right. In the interest of expediency, I'm going to ask for a vote, but a vote on the document with that particular line, shackling or similarly restraining the youth stricken. Annie, are you agreeable to doing that?
Yep.
All right.
I'm agreeable to doing whatever the commission would like to do.
All right. So asking for a vote on approval of that, Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Calderon,
Thank you, everybody. Yes.
Commissioner Crispin. I'm sorry, Commissioner Crispin?
Okay.
You said yes, but unaudible.
Thank you. Commissioner Hall?
Yes.
Commissioner Kazarosian?
Yes.
Commissioner Talley?
Yes.
I'm also a yes, so that's unanimously carried. And next, Internal Affairs and Officer Complaint Investigation Procedures.
Thank you, Madam Chair and Commissioners. Let me begin sharing my screen again. All right. So our second standard for today is Internal Affairs and Officer Complaint Investigation Procedures, which I'll refer to as IA for short. A copy of this standard is drafted, is available starting at page 90 of your packet. In developing this draft standard, I consulted a diverse variety of resources, including but not limited to best practices as identified by the Department of Justice, law enforcement interest groups, as well as reform-minded groups. I also looked at policies that have been implemented by agencies in the Commonwealth and also in other states, independent reports of certain agencies in the Commonwealth, and statutes and regulations already in effect in the Commonwealth, as well as public comment. Those resources identified 11 topics as key elements for inclusion in an IA standard, which is listed on the right side of your screen. As I present these shortly, a number of these elements will be familiar to you, as they were also included in the Criminal Investigation Procedure Standard, which the Commission preliminarily approved in November. And so starting with key principles, to foster the community's confidence in officers and ensure that agencies are able to provide effective law enforcement services, we propose that an agency's IA policy should emphasize officers' duty to act professionally and ethically, be worthy of the public trust and authority given to officers, and finally, to uphold transparency, accountability, and responsibility principles. The second element is reporting. To facilitate and encourage reports about an agency and its officers, whether those are positive or negative, the draft standard suggests that an agency's IA policy should address first what topics may be reported as a potential IA matter. Second, the methods by which such reports may be made. Third, conduct the agency and its officers may not undertake when someone seeks to make or makes such a report. And so with respect to the topics, agencies should enumerate some of the most common topics that may form the basis for potential IA matters, such as conduct in the field, conduct in the workplace, bias, harassment, or discrimination, sexual misconduct, domestic violence, and retaliation. This is not meant to be a limit to the topics that may be reported as a potential IA matter. but rather to ensure that the public and officers are aware of some of the topics that may be reported. Further, agencies should be clear that reports may concern not only an individual officer's conduct, but also the agency's policies, sub-policies, regulations, practices, and customs. With respect to methods, agencies should establish, as is within their means, a variety of easily accessible methods by which individuals may make reports for IA, meaning, in person at the agency, virtually, over the phone or over the internet, orally, and by writing, to reduce barriers to reporting, such as intimidation and language differences. Agencies should allow reports to be made anonymously via a third party in languages other than English, to a non-officer within the agency, and to a non-agency individual within the agency's larger governing structure. With respect to agency and officer conduct, to avoid inadvertently deterring and to prohibit retaliation against any individual, whether a member of the public or an officer who seeks to make a report for IA, agencies and officers should be prohibited from engaging in certain behaviors. Those prohibited behaviors include requiring a prospective or actual reporter to make their report under oath, conducting a criminal background, warrant, or immigration check of that person, requiring that person to waive any rights they may have under the law. I want to be clear here that we're not suggesting that agencies and officers should never do these things. Rather, we're prohibiting these behaviors only when that behavior is intended to discourage, intimidate, or retaliate against a potential reporter. And this is the same language that appears in the Criminal Investigation Procedure Standard. And similarly, if and when an IA investigation has been initiated, the officer should be prohibited from attempting to convince the person who reported to withdraw or abandon their report and from retaliating against that person. Our next element relates to review and screening. As matters of best practice, agencies should allow prospective reporters to review their statements for completeness and accuracy prior to finalizing a report for IA consideration. And second, agencies should screen all the reports regarding an agency or its officers for the purposes of determining, first, its obligations to the commission under 555 CMR 1, which pertains to procedural rules, and second, whether to initiate an IA investigation. Next is management. Similar to what's in criminal investigation procedures, agencies should detail requirements concerning the management of an IA investigation. Those requirements should cover the entire IA process from initiation to discipline, and should address topics such as personnel involved in an IA investigation, recommended time limits, documentation, case file maintenance, and confidentiality. One addition that we do make to this management section that is not in criminal investigation procedures is about appeals, and that's because the results of an IA investigation may affect the terms and conditions of an officer's employment that in many cases is subject to the terms of a collective bargaining agreement. And so agencies should also include requirements concerning the appeal of any decision or action resulting from an IA investigation. You'll see in the draft that's in your packet, we do not specify those requirements in order to accommodate the collective bargaining agreements that are already in place. Next is records retention. Agencies should include a sub-policy or provision concerning the retention of records associated with an IA investigation that complies with applicable law and regulations, including the Public Records Act, as well as the Commission's regulations on record maintenance and auditing. Next is conflict of interest, which is also an element in criminal investigation procedures. And this is really to ensure the integrity of an IA investigation and promote public confidence in the agency and its officers. A conflicts of interest sub-policy or provision should first prohibit an officer from conducting an IA investigation where they have an actual or potential conflict of interest. And similar to criminal investigation procedures, we say that a conflict of interest exists when an officer seeks to conduct an IA investigation in whole or in part that involves a member of the officer's family or an individual with whom the officer has a close personal or business relationship. A conflicts of interest provision should then address the requirements for reporting and evaluating a potential or actual conflict of interest. And finally, should address the management of an actual conflict of interest, including measures that will be taken to prevent the conflicted officer from interfering with an IA investigation, and the circumstances under which an IA investigation will be referred out because the agency cannot adequately manage the conflict of interest. This could potentially, when I say refer out, such an example could be when the chief is a subject of an IA investigation, and because of the power dynamics between the chief and all the other officers within that agency, that investigation may need to be referred out because that agency has no way to conduct that investigation with that conflict of interest. Our next element is on referrals. And so because the basis for an internal affairs investigation may include conduct that may warrant action by an entity in addition to the agency, such as a commission or a DA, agencies should require set requirements concerning the referral of an IA report to third parties. Such requirements should cover who such reports will be referred to and under what circumstances. So, for example, a report alleging potential criminal behavior should be referred to a DA of competent jurisdiction for potential prosecution as a criminal matter. Another example is a report alleging failure to comply with the commission's requirements, including training requirements, should be referred to the commission for potential enforcement or administrative action as a matter affecting that officer's ability to maintain their post-certification. The next element is communications, which again is similar to what was in criminal investigation procedures. And so this says that an agency's IA policy should also include requirements concerning communications about an IA investigation with the investigated officer and appropriate agency personnel, the individual who made the IA report, the commission, a local civilian oversight board, if one exists, as well as the public. And those requirements should address if and when such information regarding an IA investigation will be communicated with a party. And we understand that what may be communicated and when differs depending on who is on the receiving end of the communication. But we leave that again to agencies to sort out. Next is tracking and analysis. And so to encourage accountability, an agency should also be required to, on at least an annual basis, collect, track, and analyze reports regarding IA reports made against the agency and its officers to identify first, trends in reports over time, second, officers for whom early intervention may be beneficial, third, changes to policies, sub-policies, provisions, rules, or regulations that may be beneficial, and four, best practices that should be replicated across an agency. And to encourage transparency, we recommend that an agency be required to issue to the public an annual summary of reports that covers the above analysis that we're asking agencies to do. Our penultimate element today is internal inspection and auditing. And this is to ensure that an agency's IA is functioning in an optimal manner. And so an agency should have, as part of its IA policy, a sub-policy or provision concerning the internal inspection and auditing of completed IA investigations. And the ultimate goal there is to determine whether a change to any of the agency's policies, sub-policies, provisions, rules, regulations, patterns, practices, or customs may be beneficial. And then, as always, our last element is training. Agencies should ensure that all officers are trained in IA in accordance with all applicable requirements. As with all of our standards, we're consulting with the MPTC, and I expect that I'll be back before the commission in due course. And so with that, I'm happy to take down my screen and answer any questions.
Commissioner Calderon?
I'm not sure if this is for Attorney Leo or who it goes to, Madam Chair, but the time limit portion that's in there, I guess I would phrase it as, shouldn't we be looking at implementing standards and timeframes that need to be adhered to with some real teeth, some ramifications, some type of responsibility by the departments that, if not met, come with the burden of something. We need to hold departments responsible for their lack of investigating in a timely fashion. And when I speak, I usually speak on the behalf of Boston because that's where my expertise lies. We have statute of limitations for criminal behavior, for crimes in the Commonwealth, but there's no statute of limitations for simple rules and regs violations within the department. We have in our own department a lack of follow through in a timely fashion, even though the post has recommended 90-day standards, 180-day standards. There's no real teeth there. There's nothing that we can do to a department that just decides they're not going to adhere to the standards we have. So I'm curious if we can and how we go about doing that, because at least in my own department, and I'm trying to be professional in the way I present it, it seems completely unfair and contrary to the idea that the general public has to hold people accountable. If we are, as a department, investigating for 3, 4, 5 years, sometimes 10 years, an officer who violated a rule and regulation, but yet there was never closure for that officer, for the department, or for the complainant who wants to know what happened on the complaint. And it seems ridiculous, to me anyway, and to many people that I speak to of all ranks, that we can't have that time frame put in place, because it's absurd to have an officer that's accused of an inappropriate behavior to a pedestrian outside. It gets investigated for 9 years. And then the department wants to set a suspension standard after allowing that officer to continue working on the street for 9 years with an unblemished record, but then they want to punish him. I hope that came out. I know it's jumbled, but hopefully you understand what I'm trying to say, and I don't know who I'm directing that to. I see the executive director with his hand up, Madam Chair. I don't know who it's for.
And I think actually before the executive director put his hand up, Commissioner Calderon, Commissioner Baker had done so. So let's hear from him and then from Enrique, please.
First off, I just want to go on the record. I'm not speaking out against what Officer Calderon just said. I agree with what he just said. I'm just, this is more so for basically if you have an investigation that might require, maybe it requires a federal agency, maybe it requires the court system, maybe it requires the district attorney. Sometimes you're at their mercy of time. So it definitely can't be a one size fits all, because if you're conducting an investigation, but now you do bring in that outside entity for transparency, you're now at their mercy. And again, for the record, I'm not stating that a simple violation should take years. That's not what I'm saying. But I'm just saying when you bring in those outside people, sometimes, those days or those limitations may need to be extended.
Chief, I completely agree, and I'm sorry for jumping in, Madam Chair. Completely agree on the DA or outside agency investigations. I was strictly referring to internal rules and regulations violations or accusations of discourteous treatment, simple things that, hey, we know if the officer used profanity against somebody on a traffic stop or not. It shouldn't take 4 years to complete that investigation. And I'm only speaking on the Boston side. I'm sure I'll get spoken to about bringing it up, but it's completely inappropriate. It's gone on for 3 decades that I've been around. So some structure and some mandates would be good.
Thank you. Enrique, please, and then Commissioner Talley.
Yeah, thank you, Madam Chair. Let me mention a couple of things in response to Commissioner Calderon's point. So we will continue to report publicly, like I have done in the past, about every quarter on agencies that are not in compliance. That's sort of like the first level of addressing this issue. The Division of Standards has discussed internally and with me, and we have the intention to start bringing something that we're going to call notice of non-compliance, which would perhaps be a second, also reported publicly, reported to you, but then documenting now, the next step of such non-compliance. So some of those are forthcoming, Commissioner. We then would have the ability to administratively suspend a high-ranking individual if an agency is not is, let's say, have multiple notices of non-compliance. That's the plan. We didn't want to go directly to administratively suspending somebody without first notifying them. And the legal department has begun to think about potentially issuing regulations around fines and penalties. We would be perhaps the fourth level of progressively addressing something like this. Now, we have the authority under the statute, we believe, to issue fines and penalties, but because of the consequences, we really need to address it via regulation, and that's really the next level of addressing this topic.
Thank you. Commissioner Talley.
Thank you, Madam Chair. I agree with my colleague in that some matters of offenses, especially minor, shouldn't take a long time. I agree with that. Where there's matters that have to depend on external organizations to handle certain pieces of it, I think maybe some communication in that the matter's being worked on. We're waiting to hear back from such and such agency so that people aren't in the dark thinking, they're just dragging their feet.
Thank you. Does any other, yes, Commissioner Christman, please.
Yeah, just real briefly again to kind of add on to what Commissioner Calderon said. I think what happens in those circumstances, you may have one incident that occurred 6 years ago, then you have another minor incident that happened 5 years ago, and then next thing you know, 7 years have gone by, and they lump all these offenses together. It then looks like that officer should not be a police officer, right? And rather, if the department had addressed it very early on with that officer issued some kind of sanction, potentially that would have addressed the issue. But when it lays there for 7 years, I think it's a disservice to both the complainant and to the officer. So I think to the extent that we have these rules and there are no sanctions, there are no ways of enforcing them, departments will continue to do what they do.
Thank you. Commissioner Calderon again.
Just quickly, referring back to the executive director, thank you for where we're going with this, and I'd like to weigh in early as you're starting. The sanctions need to be at the head of the agency, whether it's my civilian commissioner or a chief of the department, because a monetary fine, they're not going to pay it. It comes from the municipality that they represent. So there should be responsibility all the way at the top because they're the end decision maker. And this stuff, as you heard, Commissioner Crispin, who's formerly of Internal Affairs here in Boston, he fully understands our specific need, that things cannot go on for several years. Those need to be closed, and the people that filed the complaint need some closure. Thank you. Appreciate the time.
Thank you. Any other commissioner wish to add any comment or question at this point? If not, Attorney Lee, thank you very much for your presentation, for its detail. And I think we have certainly in the discussion given you some additional issues to address. I think with that, we can move on. The next item on the agenda, there are no matters which were not anticipated by me as chair at the time of posting. Therefore, I would now entertain a motion to go into executive session, commissioners, in accordance with General Laws, Chapter 38, Section 21A1, to discuss the discipline or the dismissal of or the complaints of charges brought against a public officer, employee, or individual under the same statute, Section 21A5, to discuss the investigation of charges of criminal misconduct under the same statute, 21A7, combined with General Laws, Chapter 60, Section 8C2, and to the extent they may be applicable, General Laws, Chapter 6, Sections 168 and 178, to discuss matters relating to preliminary inquiries and initial staff review concerning whether to initiate such inquiries, and also regarding certain criminal record information, and under the same statute, Section 21A7, combined with Chapter 38, Sections 22F and G, to discuss and to approve prior executive session minutes. We will be addressing Division of Standards reports of preliminary inquiries in 2 cases, an application for voluntary relinquishment of certification in a single matter, the Division of Standards request to enter voluntary decertification, suspension, or disposition agreement in 4 cases, the standards request for approval to conduct preliminary inquiries and/or impose a suspension in 7 cases. And we will also be addressing approval of the minutes of the prior executive session, that is the December 28th, 2025 meeting. Is there a motion to go into executive session?
So moved.
Is there a second?
Second.
Commissioner Baker, please.
Yes.
Commissioner Bluestone,
Yes.
Commissioner Calderon,
Yes.
Commissioner Crispin,
Yes.
Commissioner Hall,
Yes.
Commissioner Kasserosian,
Yes.
Commissioner Talley.
Yes.
I'm also a yes, so that's unanimously carried. Members of the public, we will not be returning to the public portion of the meeting. Let me not end this meeting without, on behalf of all the commissioners, thanking the staff who have worked so hard on all of the matters that have been presented, and thanking the presenters of those matters today. Enrique, do you just want to remind the public? Also, I want to thank the public for participating. Do you want to remind the public, if they wish to communicate as to anything we've addressed, how they can do that?
Thank you. Yes, by sending an email to post-dash with comments at mass.gov, going to our website, mapostcommission.gov. There's all kinds of resources to contact us via that website.
Thank you. And I think with that, commissioners will take a 5-minute break before we go into executive session. And again, thanks to everybody.